The doctrine of colourable legislation is based on the principle that what cannot be done directly cannot also be done indirectly. So, a colourable legislation is a statute which is attempting to achieve something indirectly that it cannot achieve directly. For example, if the Parliament wants to ban the sale of soft drinks, but if it does not have the jurisdiction to do so, then it cannot pass a law to directly ban the sale of soft drinks. So, the Parliament can try to achieve this objective indirectly by passing a law that increases the tax on the ingredients used to manufacture the soft drinks. And the tax can be increased to such a high level that the soft drinks can no longer be sold at a reasonable price. Thus, the Parliament has indirectly achieved something that it could not achieve directly. In 2015, the Supreme Court struck down the National Judicial Appointments Commission Act, which would have changed the process of judicial appointments in India. One of the views there was that this was a colourable legislation because the executive was indirectly trying to control judicial appointments, something that it could not do directly. Therefore, the legislation was against the concept of judicial independence. From a federal structure perspective, the doctrine of colourable legislation comes down to evaluating the jurisdiction or the competency of the legislature. If the state legislature is trying to make a law that is indirectly trying to have a significant effect on a subject that is in the central list, then it is a colourable legislation. Or if the Parliament is trying to make a law that is indirectly trying to have a significant effect on a subject on the state list, then it is a colourable legislation. In the K.C. Gajapati Narayan Deo versus State of Orissa case, the court clarified that when it comes to colourable legislation, it comes down to a question of whether the legislature has the required competency or not. If the legislature lacks the competency to pass the law on a subject, then the question of the motive of the legislature does not arise at all.